Good evening. I'd like to start off by thanking Steve Simmons and the Moscow Human Rights Commission for inviting me here today. I currently teach at the University of Idaho Law School program in Boise, but I spent my first 3 years at the university was up here in Moscow. And so it's always fun to come back and see old friends and my colleagues here. There's quite a bit that I miss about the city. So anytime I get an invitation to come up, it's something I give a lot of serious thought to. I'd also like to thank Linda Martin for paneling this discussion tonight with me. I've seen you're in a lot of interviews, I've read a lot of interviews, we've probably been in a lot of co-coverage on this, and it's finally fun and really great to meet you in person. And then I'd like to thank all of you today who are here for just taking time out, for your interest in this topic, and hopefully for what I expect will be a really great discussion after our remarks. And so I am going to try to focus most of what I say on sort of the legal context. Now, as I've discussed this issue over the past few years, I've really had some time to give it some thought and think about sort of what is the issue here, right? Is this a religious freedom issue? Is this a parental control issue? Is it a sort of child rights issue? And I've come to somewhere in between. For me, this is really a question of a parent's right to religious belief and parental control as juxtaposed against that child's individual right to life and liberty. And so that's where I'm going to sort of focus my remarks. I'm going to start off by sort of outlining what is one's right under the religious clauses, and then sort of what are parental rights from a constitutional standpoint, and then talk a little bit about sort of what are the child's rights, right? What are the constitutional rights at stake for children? And then I will sort of talk a little bit about this intersection between parental rights and child rights, and then maybe try to probe us to think about sort of, well, what are our solutions? What do we do beyond just sort of, getting rid of these statutes, which may be politically unpopular, sort of thinking more in terms of amending the statute, sort of what are our options, or at least what have I been thinking about. So when we talk about religious freedom, we really tend to focus our minds on the First Amendment. Now, first of all, let me just say, just because it's the First Amendment does not mean it's the number one amendment. It's just sort of the order in which they were written. And so that does not mean sort of that there's religious belief sort of trumps everything else. I guess no pun intended there. So first, when we talk about religious beliefs, it's important to understand that there are two separate types of religious belief that are provided under the First Amendment. The first falls under the Establishment Clause. The second falls under the Free Exercise Clause. Now, these are two separate clauses, although they're weirdly interrelated, but they're also in tension with each other. So the Establishment Clause establishes this sort of absolute right to believe. And when I say absolute, I mean absolute. It is one of the few absolute rights that exists under the United States Constitution. Basically, it's this idea, you get to believe whatever you want to believe, right? You can call it religion. You don't have to, though. You can call it non-belief. You can call it freedom of conscience. You can call it whatever you want. And guess what? If you call it religious belief, you don't have to believe in God or any other type of supreme being. If you decide that pink unicorns is how the earth is created and what you would like to pray to, guess what? You have the absolute right to believe that or anything else that you like to believe. part of the Establishment Clause, and that is sort of this limit on government power and government authority. In this sense, the government is not allowed to either establish any type of government religion, nor can the government enact laws that have the effect of preferring religious belief over non-religious belief, or even vice versa. And so the Establishment Clause does two things, right? It establishes this absolute right to belief, but also acts as a limit on the government. And again, that right to belief can be religion, non-religion, and any and everything in between. And really everything outside of those boxes as well. Now, that's the Establishment Clause. Turning our attention to the Free Exercise Clause, it is not absolute. Now, first with the Free Exercise Clause is sort of this right to engage in behavior that furthers your belief. Again, religious versus non-religious, whatever. But it's this right to actually engage in those tenets of one's faith or non-faith. And so, but as you can imagine, this is a qualifying right. Because if it were absolute, it means anything that you've done, any conduct that you've been engaged in, as long as you sort of stamp your belief on it, it would be fine. And as we know, that is not the truth, right? As much as I may want to bow down to the altar of cocaine use, I will go to jail if I do that and I am caught by the government. Why? Because that is a crime. And so the Free Exercise Clause does not prevent the government from establishing laws of general applicability. As special criminal laws, the court has very clearly ruled that the government can impose criminal laws. A famous case about a decade or so ago by Justice Scalia dealt with the use of peyote. And this idea that, well, you know, there was an argument that certain beliefs encourage and require the use of peyote. The court said, hey, you know what? It's okay to make that a crime. And just because we're prosecuting you for it does not mean that we're in violation of your right to free exercise of your beliefs. So that's kind of where we stand when it comes to that First Amendment religious freedoms. Establishment Clause, free exercise, they both kind of are very interrelated, but one is sort of absolute, one is very qualified. And to whatever extent their scope is, at least when it comes to the Free Exercise Clause, there is this ability for the government to impose laws that kind of apply to everyone. And just because they may burden one's religious exercise or does not necessarily mean that there is a First Amendment violation. So the other part of this from the parental standpoint is that parental right. So there is this idea that under substantive due process, that there are parental rights, right? The right to care, custody, control over one's offspring, whether they're natural children or adopted or there's some other legal relationship there. So, and that's a very broad set of rights that have been established by U.S. Supreme Court jurisprudence. That means that a parent can choose if their child learns German or not. You may be surprised to find that in some states in the United States, they said, we should not have children learning German in school. And the court said, if that is what parents want their children to learn, they have that ability to choose that type of education. Of course, where that comes into play here is this idea of the right to choose the care for your child, right? You get to choose your doctors, at least what your health insurance plan, that list they give you, right? You get to make all of these medical decisions for your offspring and your dependents. And as you can imagine, however, that too is not absolute. There are all types of laws around parent control, right? Termination hearings, right? The government has the ability to terminate your parental rights, and one of the most classic grounds has been child neglect. And so now what we have is a law that appears to provide some exemption to this general criminal law and sort of civil law that allows for the termination of one parental rights. And the basis for creating that exemption appears to be some type of religious exemption. And so I could give you more examples of where parental rights have been limited. For example, you can't force your children to marry, right? Even if your child is underage but still qualifies for marriage under the law, parents can't sort of drag them into before the altar and force them to get married. You cannot force your child to abort a child, right? If your female child is pregnant and she's underage, you cannot force that child to have an abortion. In some cases, you may not be allowed to force that child to actually give birth either. There is some wiggle room under abortion jurisprudence to allow for the child to go around their parents when they cannot get consent. Here's another one. You can choose whatever education you want, but you cannot choose not to educate your children. Very clear U.S. Supreme case law that says your child has to be educated. Now you can do it at home, right? You can choose a religious school or a non-religious school. You can choose public versus private education. But you have to educate your child no matter what your beliefs are about educating your child. And all of these sort of state laws are centered around this right of the state to protect children, which is a right up until these type of laws, where the state seems to be very expansive in its desire to sort of protect children, right? To the point where they will terminate your parental rights, to the point where they will dictate prior to birth sort of what hurdles you have to go through if you'd like to seek an abortion, for example. These types of, the normal position of the state is that we want to protect children as much as possible. And so that's sort of on the parental rights end. Where the tension lies, I believe, is with what rights does that child have independent of their parents? And this is an area that you may or may not be surprised to know is not incredibly well developed under the United States Constitution. Very few cases deal solely with sort of what are your rights as a child. Normally, when we think about our constitutional rights, in particular our individual rights and liberties under the Bill of Rights, we think of the adult person, right? We rarely think of the minor. But we certainly have some clues that I think if we sort of put the puzzle pieces together, we can get some basic framework down. So first, there is a right to life and liberty under the due process clauses that applies to children. So that right to life under due process for those who are born, even if you are minor, seems to be one of the highest of the protected rights under due process, right? That is sort of, we all talk about, I have a right to due process, right? Mom, you can't come in my room because I have this right to keep you out. So it's pretty clear that there is a right to life that applies independently to that child once they're born. A lot of the question comes in, well, where is that child's right subordinate to that parental right of control? Well, what we see in different areas is that the court does not or has not held that the child's right is completely subordinate to their parents. So children, it's been established that there is this independent right to freedom of speech. And that applies sort of that's a personal right to the child. It applies in the context of schools, which is where you see most freedom of speech cases. Now, there is some ability for the school to maintain discipline and control, but in general, there's tons of case law that talks about the child's independent right to speech. And that speech is not dependent on what their parents say or think. There is this independent right to privacy that children have. Now, to some extent, that is somewhat subordinate to the rights of the parents, but there is still that right that exists. There are limits on the government's and a parent's ability to sort of probe into the private recesses of a child's mind. So there we see that there is some right to privacy that children enjoy. Children also enjoy criminal procedure rights, right? Your parent cannot go into court or into the police station and give a confession that could be attributed to you, right? Your parent can't say, oh, my child took the fifth. Well, guess what? I am waiving their right to the fifth, and I am confessing to this murder that my child committed, and you can sort of use that as my child's confession, right? That's really not allowed. When children are in criminal procedures, they have their own right to counsel. And that attorney does not get to dictate or has to do what the parents want them to do. Even if the parents are paying for it, that attorney's client is the child, not the parent. And so I think criminal procedure gives us a lot of good examples of where a child's right does not become subordinate to their parents simply because they're a minor. So what does all this mean? Well, one, I think I'll say sort of, for me, what does all this mean when I think about all of this and sort of try to list it out? Well, one, this law certainly demonstrates that there is a lot of tension between parental rights and child rights, right? What is the scope of that parent's right, and how does that intersect or interact with that child's whatever individual rights and liberties that the child has. Another issue with these laws for me is I do wonder whether these laws have given a preference to religious belief, especially in the language of the statute itself, these terms, spiritual means or prayer. Well, what if a parent engages in the same behavior but has no sort of spiritual meaning and did not pray over that? Does that mean that they would be prosecuted even though they are engaged in the same behavior, and therefore the only difference between whether one is prosecuted or not prosecuted is whether they have some type of religious belief? If that is true of Idaho's law, then how does that jive, if you will, with the Establishment Clause, which is very clear in its prohibition against preferencing religion over non-religion or any type of other belief. Another issue is that I do wonder whether we have children in the state who are falling into this black hole. It is very clear from some of the reporting that we don't even really know if coroners are going to conduct autopsies to verify how the child came to be in the state that it's in. We don't really, because we don't get a lot of coroners reports, we don't know if prosecutors are really looking to see if that child's death are within the parameters of this exception. And because of that, as a citizens of the state of Idaho, it could possibly be that we are ignoring what could ultimately end up being a very serious health and safety issue for children. And to the extent that one of our values as a society is the protection of children, then one has to wonder why our collective lack of curiosity on this has allowed things to go as far as they have. And then finally, I do wonder that if the state does start to investigate more, then is that causing the state to have to sort of probe into these religious beliefs and the veracity of these beliefs, which U.S. Supreme Court case law clearly prohibits the government from doing, right? Case law says you can't say whether someone is really a Christian or really a Muslim based on their practices. You kind of just have to accept that they said that they are a Christian. And it doesn't matter that they don't even believe in Christ. If they say they're a Christian, then as the state, we kind of have to accept that. So if we do have this law that creates this religious line, and we begin to investigate, is that causing the state to have to make judgment calls and say, well, really, was that prayer or not prayer? Does this qualify as spiritual means? And I would not have to be the prosecutor who's going to make those types of judgment calls. So with all that, what can we do? Sort of where do we go? First, I would really urge Idaho to reconsider the use of the terms spiritual means and prayer in the statute. One, because I think these terms have a very clear religious connotation, and to the extent the law or the state seems to allow prosecutions to be based on religious belief versus non-religious belief, I think these type of statutes may fall on the wrong line of the Establishment Clause to the extent that it may be preferring religion over non-religion. And clearly, again, clearly the case law says you cannot do that. Two, I wonder why not have some type of safety valve for the child. To the extent that there is a child who is ill and whose parents do not want to pursue any type of medical intervention, I feel like there should be some procedural mechanism for the child to sort of go to court, maybe through, get a guardian system, maybe appointed counsel, like in parental termination cases and things like that. Create some safety valve for that child to be able to sort of go around those parents. And we know that that's required in the context of abortion. If there's a child who would like to get an abortion, the parents don't agree, the U.S. Supreme Court has said you have to have some type of avenue for the child to go into court and get a determination from a judge of whether or not giving birth is in their best interest. And I think here, that can work the same way. If there's a child who'd like to go around their parents, there should be some mechanism for them to go into court, get counsel appointed, and have a judge determine what is in that child's best interest. And be through that, ultimately recognizing that there are some rights that the child have, and that those rights sort of expand as that child gets older. I think a 15-year-old is far better able to make decisions for themselves than a 5-year-old, or I should say most 15-year-olds are able to make better decisions for themselves than most 5-year-olds. And so I think as we begin to recognize that children have more autonomy and more authority as they age, even as minors, I think that this law could be amended in a way to recognize that fact. And then finally, I think Idaho has to, absolutely needs to, meet its duty to investigate and report these deaths. I do not believe that that will cause too much interference in the personal lives of individuals who would directly be affected. But to the extent that we have a mechanism in every other respect where if there is a killing, especially in the cases where someone dies, there's some attempt to establish a cause of death, right? To establish whether there is someone who's responsible criminally or civilly for that death. To make sure that our records are correct so that we can track deaths that come from heart attack versus cancer versus in other types of diseases or even accidents, whether through products or our own individual following. The idea that we sort of allow, that we could potentially allow health issues that are in the public's interest to go unnoticed is a little bit concerning. Finally, I think that there needs to be some recognition that the decisions that are made for you as a child have the ability to affect the rest of your life. Your ability to pursue an education, to pursue a profession, your general ability to live your best life. And so to allow children to be so affected at that way when they're at their most vulnerable seems to me a little short-sighted, because we fail to recognize that as children age and become adults, if there are serious health issues that they suffer from, and they're undereducated and maybe underemployed, then there is a public, that becomes a public issue to the extent that individuals may need public assistance and all of those types of things. And so I don't know if we're thinking long enough for this. And I think there is a general idea that there's so few children affected that really it doesn't matter. But I would beg us to not look the other way simply because we think that there are so few people affected. So that sort of concludes my, I don't know if they're opening remarks or whatever, but I'm really looking forward to having a broader conversation with all of you in this room and sort of hearing your thoughts. And so I thank you for listening.